Hi everybody, good afternoon. Thanks for joining us for the webinar. Sorry we had a little bit of technical difficulty. We got a lot of messages from folks saying they couldn't hear us. That was on our end. We had to restart, so apologize for that, but we've made it through and we're ready to roll, and we really appreciate everybody joining us. We can go beyond 3 o'clock to make up for the 5 or so minutes that we're behind here, so if you can stay with us the whole time, that's great. And if you have to jump off right at 3, the entire webinar will be available when we're done. We'll email it out to everyone, including the slides. So if you're interested in getting the slides or want to listen to all the content, you'll get a link probably later today or by tomorrow, so you can have that all at your disposal. And again, thanks for joining us. We're going to get started on the webinar, Identity of Interest Affiliation, Everything You Need to Know. I am John Williams. I'm one of the partners here with PilieroMazza. I'm in our government contracts group, and I'm joined today by Julia DeVito, one of our associates who works in government contracting as well as litigation and the small business programs. Most of you, I'm sure, have some familiarity with us. That's how you got onto this webinar, but I do want to spend a little bit of time telling you about our firm. PilieroMazza is a full-service law firm in Washington, D.C. We also have an office in Boulder, Colorado. We're most well known for our government contracting practice, which is really a soup-to-nuts government contracting practice, everything that you might encounter doing business with the federal government. But we also have other practice groups, small business programs, labor and employment, business and corporate, and litigation. And we really pride ourselves on the wide and diverse types of matters that we can handle for our clients. We serve essentially as a virtual in-house counsel for many of our clients. And if we haven't worked with you before, thanks for joining us, and we hope to have a chance to work with you in the future. So with that, I'm going to turn to our content for today. We're talking about identity of interest affiliation. So we're going to start off by setting the stage for why do we care about affiliation? Why are you all listening to us tell you about this aspect of SBA regulations? Well, we care about affiliation because we care about our small business status if we're doing business with the federal government as a small business, or if we're a larger business when we're partnering with a small business, then we care about affiliation because it affects small business status. So we'll give you an overview of that, and then we're going to really drill down on identity of interest. There are several types of affiliation, as we'll talk about today, but we're really going to focus just on identity of interest affiliation. Today we're going to talk to you about the different types of identity of interest affiliation. We're going to give you some tips to avoid or mitigate identity of interest affiliation. And then we're hoping to leave about 10 or 15 minutes at the end of the presentation to answer questions that you can ask throughout the presentation. I see we already have one question that's come in. Thank you for that. And please feel free to just fire away throughout the presentation. So if we can, we'll answer as we go along, or we're going to try to save, like I said, a few minutes at the end to answer questions. And any questions that we may not be able to get to during the webinar, we will follow up with you by email afterwards to make sure everybody's questions answered. So don't be shy. It's all anonymous. Just type them in the chat box, fire away, and we'll do our best to answer everybody's questions. Okay, so why does size matter? Well, it matters if you're, like I said, if you're doing business in the set-aside programs, because it's the #1 eligibility requirement for all the set-aside programs. I mean, it's sort of a forehead slapper, I guess, but you have to be a small business to participate in the small business programs. And being a small business also exempts you from certain requirements that apply to other contractors, such as reporting executive compensation and how robust of a code of ethics you need to have, and cost accounting standards. There is also increased importance on making sure that you're following the small business rules the last few years since SBA implemented its presumed loss rule. This presumed loss rule allows the government to go after a contractor for the full amount of a contract that the contractor received based on a misrepresentation of small business status. So that really increases the potential damages that you could face if you misrepresent your small business status. So that's just underscores the importance of making sure that you're small and that if you're participating in these programs, that you're doing what you can to protect that very important asset, your small business status. So how does affiliation impact size status? First of all, let's just make sure we're all on the same page about how the SBA determines your small business status. Depending on your industry, they're either going to look at your revenues or your employees. So there are size standards associated with each industry, and that's by the NAICS codes. And the size standard's either going to be revenue-based or employee-based. If the size standard is revenue-based, then the SBA is going to look at your average annual receipts over the 3 most recent fiscal years. And if that average is below the size standard for the NAICS code, then you are a small business for that industry. If it's an employee-based size standard, they're going to look at the average number of employees for each pay period over the past 12 months. So that's how SBA determines whether you're a small business. If you have an affiliate, they're going to include the revenues or employees of your affiliate when they determine your small business status. So what that means is that you might be small on your own. Your company's annual revenues might be below the size standard, or your company's employees might be below the size standard. But if SBA considers you to have affiliates, those affiliates, their revenue or their employees could push you over your size standard. So the bottom line is that affiliation could wreck your small business status. And that's why it's so important to understand how affiliations can arise so that you could take steps to mitigate or avoid it if it might be relevant in your case. Affiliation can have different meanings, but in the context of SBA and their small business programs, affiliation is all about control. SBA's rules look at whether one firm has the power to control another, or a third firm has the power to control both. And control can be affirmative or negative. So affirmative control would be, there's a right in the agreement that affirmatively allows me to control the company. I make all the decisions, so I affirmatively control the company. Negative control would be where I may not affirmatively have the ability to control the company, but I have the right to block the other owners from taking certain actions. I have a veto right, or there's a unanimous consent requirement that I have to go along with in order for the company to act. And that can be considered negative control because I can control the company by refusing to go along with what the others want to do, or by exercising my veto right. And in the SBA's eyes, it doesn't matter if the control is exercised as long as the power to control exists. An affiliate can be any business entity, whether for-profit or non-profit, domestic or foreign. And affiliation, when we're talking about protests, and we're going to get into that as we move forward, because that's how affiliation will typically come up in the context of a protest that your competitor may file against you. Affiliation is going to be determined at a specific point in time, and that's generally the date you submit your initial proposal with price. And the reason for that is that the date that you submit your initial proposal with price, that's the date that SBA is judging whether you were a small business in the event that a protest is filed. That's the magic date for small business status. You have to be small. If you're submitting a proposal for a small business contract, you have to be small when you submit your initial proposal with price. So if SBA comes in to determine if you were small on the date you submitted your initial proposal with price, they're going to look at whether you had any affiliations as of that date. And it won't necessarily, it's not going to help you if those affiliations went away after the date you submitted your proposal, your initial proposal with price. I mean, maybe with a few exceptions, but by and large, you need to be small. You definitely need to be small. And if you have affiliations, they need to be broken before you submit your proposal with price if those affiliations will affect your small business status. And this slide 8 we're turning to now lists the different types of affiliation. SBA's affiliation rules are found in 13 CFR 121-103, and you can see that the rules list several ways that the SBA can find affiliation. They can find it based on stock ownership or common management. The ostensible subcontractor rule is a very common rule that comes up in protests. And I've highlighted identity of interest just to underscore that it's one of several types of affiliation, and that's the one that we're going to focus on today. And with that, I'm going to turn it over to my esteemed colleague Julia, who's going to start drilling down on identity of interest.
So the SBA's rule for identity of interest, as you'll see on your screen, says that individuals or firms that have identical or substantially identical business or economic interests, such as family members, individuals, or firms with common investments, or firms that are economically dependent through contractual or other relationships, may be treated as one party with such interests aggregated. Where SBA determines that such interests should be aggregated, an individual or firm may rebut that determination with evidence showing that the interests deemed to be one are in fact separate. Now this is a pretty complex rule, so we're going to break it down. So the first step is that affiliation arises when SBA finds that two or more firms have identical or substantially identical business or economic interests. So the focus at the outset is whether the interests are identical or substantially identical. And there are three common types of identity of interest. There are familial relationships, individuals or firms with common investments, and economic dependence based on contractual or other relationships. But these are not the only kinds of identity of interest. They're just the most common kind. So identity of interest can arise when there is some other connection outside the business in question that indicates that there are identical or substantially identical business or economic interests. So SBA is looking to see whether two people or two companies or a person and a company have such substantial interests, identical interests, that they should be treated as one. So just a couple examples to get us started of identity of interest. So in the first example, SBA found an identity of interest between an individual and a business because the individual was a key employee of the business and the key employee and the business shared common investments. So they had one connection outside of the business in question. The individual wasn't just an employee, they also had that common investment in common with the company. The second example we have here is that SBA did not find an identity of interest between Company A and Company B, even though Company A owned 49.5% of Company B, because outside of Company B, the two firms' economic interests were not aligned. So in this situation, the only thing these companies had in common was that one was an owner in the other company, but there was not, they didn't have a majority interest in Company B, and that was the only thing in common. So part of this rule to keep in mind is that identity of interest affiliation is rebuttable. This means that at the outset there are circumstances where SBA will presume a firm or two firms are affiliated because of an identity of interest, but that you can rebut that presumption if you are given the chance during a size determination. And when you are rebutting that presumption, you are showing that the interests that look to be identical or substantially identical are in fact separate. So the key is whether there's a fracture in the relationship between the two people or the two companies.
Yeah, and you're going to hear this word fracture a lot when you're looking at affiliation issues, because that's the term of art that we use, that when there's an affiliation, as Julia was talking about for identity of interest, and there's a very close relationship, that's so close, maybe because of a family connection or contractual relationships, that the SBA essentially views the two parties as one. They have an identity of interest. But going back to the broader context, talking about affiliation in general, affiliation is about control. The SBA perceives that there's control, one party can control the other based on certain characteristics of the relationship. So to mitigate or avoid that affiliation, you have to fracture the connection that is tying the two companies together, that is giving the one party the ability to control the other. So that's what we're talking about when we say we need to fracture the relationship. We have to look for a way to break the connections that are causing the SBA to view the one company as having the ability to control the other.
So before we get into the details of the different types of identity of interest affiliation, we just want to talk about how this can come up during a size protest. So identity of interest affiliation is becoming increasingly more common in size protests and the basis that SBA will find firms to be affiliated. So it's good to be aware of how it can arise before a protest happens to you, before someone protests your size. So competitors will often look at other firms' websites, just do some simple Googling or look on LinkedIn or Facebook to find information about companies and how they're connected with other companies. And this can include relationships, contractual relationships. It can also include looking at the owners of companies and who they're related to and whether those people own other companies. And as a result of those kinds of allegations, people can make size protests and then, or excuse me, people can file size protests asserting those allegations. And then a company that has received a size protest will have to fill out an SBA Form 355. And among the other, the many kinds of information they'll have to provide in that form, they'll have to identify all of the company's owners, officers, and directors. They'll have to identify other businesses owned by the company's owners, officers, and directors, the facilities, equipment, or personnel shared with an alleged affiliate, whether a family member of the company's owners, officers, or directors has an ownership interest in a potential affiliate, and any actual or proposed subcontracts between potential affiliates. And with all this information being turned over to SBA, even if the basis for the size protest was not identity of interest, SBA could find that there is an identity of interest that causes a finding of affiliation.
And I just wanted to take a minute to address a question that just came in that I think is a really good question and something we didn't touch on yet, because we're focusing on describing to you what is affiliation and in particular identity of interest, and as Julia was just describing how this comes up in a protest and what you would have to provide to SBA. But at the end of the day, to go back to the very first slide, why does size matter? It's all about whether you're a small business. And you could have an affiliation with another company and yet still be a small business. Because what SBA is going to do, as I was saying, is they're going to lump your revenues together with your affiliates' revenues. But if it turns out that you and your affiliates are below the size standard, then it's not going to make a difference in your eligibility for that contract. We've had a number of protests where a competitor alleges that our client is affiliated with another party, and we will either acknowledge the affiliation because they're right, there is an affiliation, or I can recall one case where there was an allegation of ostensible subcontractor affiliation, arguing that our client was affiliated with its subcontractor. And we didn't agree with that. We contested it, but we said, in any event, even if you lump the two companies together, we're still below the size standard. So, the question's a very good one, that we need to be thinking about what is the ultimate effect of the affiliation. And if you're still small, it will not impact your small business status. Now, it could affect you in other ways because, again, affiliation is about control, and if you're a participant in one of the small business programs where there needs to be a particular person who's in control of the company, like a woman or a veteran, the fact that you have an affiliation where somebody else might be viewed as controlling the company, it could have an impact on your status in those other programs. But at least from a size standpoint, if the consequence of the affiliation is that you're below the size standard, then you're going to be a small business.
Another consequence of identity of interest affiliation is that the actual ownership interests among various people or entities can be aggregated. So, for example, if two individuals have an identity of interest, such as a family relationship, and one individual controls one company, company A, and the other individual controls company B, SBA will deem that company A and company B are affiliated because the owner of each company has an identical interest, so they're treated as one person. So it's as if the same person owns company A and company B. Similarly, if two individuals who have an identity of interest own minority interest in the same company, for example, if the husband owns 30% of company A and his wife owns 30% of company A also, together, if their interests are aggregated, they will own 60% or a majority interest in that company. Additionally, if companies are found to be affiliated, they can use what's called the revenue exclusion for inter-affiliated transfers. This is a rule that allows you to not double count revenue that is transferred between two companies that are affiliated for purposes of calculating the total revenue of both companies, because when two companies are affiliated, their revenue is counted together for the size of one of them. So with this rule, when companies have an identity of interest and there is an exchange of revenue between them, this rule can be helpful in lowering the total value and in revenue of the company combined.
Yeah, there are very limited exclusions from your revenues. When SBA goes to look at your revenues, they're going to look at your tax returns, or if you don't have tax returns filed yet for a particular year, they'd look at your financial statements. And really, there's not a whole lot that you can carve out of those revenues. There are some exceptions, though, and one of the exceptions is if you have revenues from transactions with an affiliate, then obviously if they're going to count your affiliate's revenues along with your revenues, it wouldn't be fair to count those inter-affiliate revenues with both companies. That would be double counting those revenues. So they'll let you exclude those revenues, and there's been some positive developments for that exclusion within the last year that our firm was directly involved with. That SBA, Office of Hearings and Appeals, used to say that you could not use this inter-affiliate exemption unless the companies had filed consolidated tax returns, but that's no longer the case from about last summer. So just a sort of a word to the wise, if you have an affiliate, we want to be making sure we're taking advantage of this exemption from so we avoid double counting if that's applicable. All right, so we've given sort of the backdrop on why we care about affiliation and what is affiliation, and Julia did a nice job giving us an overview then of what is identity of interest affiliation. And just as an aside, we're getting a lot of questions, which we really appreciate. We're going to do our best to answer as many of them as we can at the end. A lot of the questions are geared towards other types of affiliation, not identity of interest. So we probably will not address those on this webinar, since the goal here today is to focus on identity of interest. But we will follow up with you by email if you had other affiliation questions. So again, don't hold back. Feel free to keep firing away. So the slide you're looking at now, slide 15, this is familial identity of interest. This is one of the typical ways that an identity of interest arises. But it's also one of the ways that I think clients are most often surprised by, that they don't realize that there's a presumption of affiliation between my business and my husband's business, or my son's business and my business. And that is the case. So you need to be aware of that. If you have a close family member that has his or her own company, there is a presumption of affiliation. And when I say close family member, I mean husbands and wives or parties to a civil union, parents, children, and siblings. So I don't mean uncle and nephew or cousins. The types of family members that qualify for this presumption of affiliation that's right in the regulation, it used to just be sort of through case law that was developed, but SBA put this right into their rules last year. And they're very clear that if it's not a close family member like we've outlined here, then the presumption of affiliation does not arise through the family connection. But that doesn't mean the family connection might not still create an issue for you. I mean, if your nephew has his own company and there are a lot of other connections between the businesses, the fact that there's an uncle-nephew connection may very well heighten the concern for affiliation. So I don't want you to take away the conclusion that we don't have to worry about affiliation if it's an uncle and a nephew or cousins or in-laws or some type of relationship that is not specifically mentioned as close family members, because it could still be an issue. So much about affiliation is the totality of the circumstances. I always say, how many cards are you putting on the table about the relationship between the two companies? The more cards you're putting on the table, so to speak, the greater the potential that there's going to be an affiliation. And a family connection, even if it's not a close family connection, could be a factor in finding affiliation. But it would not rise to the level of a presumption of affiliation unless it's a close family member, and it's got to be what I've listed here specifically on the slide. So we're getting some questions like, what about a brother-in-law or other types of family connections? If it's not one of these three specific bullets here, married couples, party to a civil union, parents, children, and siblings, then it's not going to fall into the category of a presumption of affiliation. But again, just to repeat it, that doesn't mean that you completely disregard the family connection in the affiliation analysis. The presumption of affiliation means that's our starting point. SBA is going to start off presuming that you're affiliated, and then you've got to convince them otherwise. So obviously we'd prefer to avoid that starting point if we could and avoid the presumption. And so this next slide, 16, gives you a couple of situations where you could avoid the presumption. And one is there has to be control. The family members have to control their respective firms. I had a case a few years ago where it was alleged that there was a familial identity of interest between a company owned by the wife and a company in which the husband was working. But we were able to successfully beat that case because the husband was working for another company, but he did not have any ownership interest in that other company. He could not control that company. He just was simply working there. And so the familial identity of interest does not arise in that case because the family members didn't control their respective firms. Only the wife controlled her firm. So there's got to be control in both of the firms. That's important by the family members. And the other is that there has to be a business connection. The presumption doesn't merely arise because of the family connection. It arises because there are family-owned businesses that conduct business with each other, such as subcontracts or joint ventures, or if there's a financial arrangement or some other kind of shared resources or personnel. There's got to be another hook there besides just the close family connection. So then that leads us to, well, how do we rebut this? If it's just a presumption, we're going to start off by saying, okay, there's affiliation, but we're going to give you a chance to rebut that presumption. I've given you some of the things that SBA would look for on this slide in rebutting the presumption of identity of interest based on family. I mentioned on the last slide, one of the things you can do is show that one of the family members does not control his or her respective firm. You can also demonstrate estrangement between the close family members. I used to jokingly say, it was like, we don't do Thanksgiving together. We're not close. And that's a little tongue-in-cheek, but there are circumstances where family members are still involved in a business, but maybe there's a divorce or there's another type of estrangement where you can demonstrate that this might look like a close family connection, but it's really not. I think that's not very often that kind of argument works, but it's at least theoretically possible if those circumstances fit your case. More often what we're arguing about is that the businesses are not in the same line of work. Yes, my brother has a company, but he does construction, I do IT. We don't do work together. I don't do the IT for him. He doesn't build my office. He works in the Southeast. I'm in the Northwest. Arguments along those lines, those are your most effective arguments for rebutting the familial identity of interest. Again, to bring it back to our buzzword, there's a clear line of fracture between the businesses. So, if there's at all a close connection between the companies in terms of what they do, my brother I'm in IT and my brother is, manufacturing IT equipment and I'm doing IT services. So those are fairly closely connected lines of business. We could still demonstrate a fracture if we can show that the two companies aren't doing work together. But that's really the key, I think, that you're not contracting with each other, you're not sharing personnel or office space. They're really independent businesses. That's what you're trying to establish. All right, so then the next slide popping up here, slide 18, is the second type of identity of interest affiliation that most commonly comes up, and this is identity of interest based on common investments. And what SBA will do is they may consider individuals or companies with common investments as having an identity of interest. And they're going to, just one single common investment isn't going to be enough. So if Julia and I each own a part of a company, that is a common investment. I mean, we both have an investment in the same company, but if that's the only company that we each have an investment in, that's not going to be enough. But if Julia and I each own a part of multiple businesses, then we're so in other words, more than one, then we're at least in the running for a possibility of a presumption of affiliation based on common investments. So at least two. One won't be enough, but two could be enough. And there are cases that say two is enough. So that doesn't take a whole lot to get into an issue with common investments. So then, besides the number of investments, being more than one, we're also focusing on the nature of the investments. How substantial are they, either in the number of investments, like there's 15 common investments, so that would be substantial number of investments, or substantial in the value of the investments. Maybe it's just a few common investments, but they're really significant, dollar-wise and control-wise. So that's what the SBA is looking for. Like the other types of affiliation that we're talking about today, identity of interest, it is rebuttable. So, again, we need to provide evidence that the interests that SBA believes are common are in fact separate. So we're trying to show fracture again, and we want to limit the number of shared investments. Obviously, I mean, that would be the easiest way to avoid this, is to not have more than one common investment. But if that's not feasible, or already there are multiple common investments, then we want to look at trying to avoid shared control of the common investments. So it would look more like, that's really my company and Julia just has a small piece of it, versus we're both sharing control of multiple companies that we have commonly invested in. And if we could make a showing that the joint investments are not substantial for at least one of the common investors, that would help. And what I mean by that is, maybe one of the investors, he's got a whole lot of other investments. And so the couple investments that he shares with me in common, those don't amount to a whole lot compared to his entire portfolio. They're not substantial for him. He's just got a little piece of some companies that I also have a piece of. So that kind of a showing. You've got to provide that evidence, though. You have to be able to document that story. All right, and now the last type of identity of interest, the three big typical types of identity of interest is economic dependence, and I'm going to turn it over to Julia.
So economic dependence arises when a firm provides, well, it can arise in two circumstances. So when a firm provides critical financial assistance to another firm, such as through loans or financial guarantees, or when a firm generates a significant percentage of its revenue on contracts awarded to it by a second firm. So in the SBA regulations, there is now what we call a 70% test. So this was first developed through the case law, and then last year SBA added it to the regulations. And it says that SBA may presume an identity of interest based on economic dependence if one firm derives 70% or more of its revenue from another firm. And the 70% is calculated by looking at the firm's 3 most recently completed fiscal years prior to the date for determining the size. So usually when the proposal is submitted, that leads to a size protest. Now there are some exceptions to the economic dependence rule. So one of these exceptions is when you're looking at how much the 70% revenue, or at least 70% revenue from another firm, that doesn't come into play when the small business is serving as a prime contractor in the relationship with this other firm where they're deriving their revenue, because as it might be common sense, but they're not deriving revenue from those relationships where they're serving as the prime contractor. So the 70% rule comes into play when the small business is serving as the subcontractor to another firm. But even if the small business is serving as the prime contractor, sometimes in that relationship between these two companies, there still could be something else that gives rise to affiliation, including based on identity of interest and economic dependence.
Yeah, I just wanted to jump in on that. So the reason that the economic dependence goes one way and not the other, this is the SBA's thinking on it, that when the small business is in the position of the subcontractor, the small business is potentially dependent on the prime contractor. They're the ones, the prime controls the flow of money. The prime's the one that awards the subcontract. So if a subcontractor is getting 70% of its revenue from one prime contractor, SBA's thinking is that subcontractor is subject to control by the prime, because that subcontractor needs that revenue. That's 70% of its revenue. So if that prime says jump, that sub's going to have to say how high. So that's why it flows that way, but not the other way. When the small business is in the role of the prime, they may be subcontracting a lot of their work to one particular subcontractor, but because the small business is the prime, they can control that. They're the ones that control the award of the subcontract. So the 70% test only works in the one direction when the small business is the sub, but it is important to note that that doesn't mean you could never be affiliated with your subcontractor just because you're the prime. I mean, that's the point we're trying to make here, that you can certainly be affiliated with your subcontractor when you are the prime, but it should not be under this 70% test. And if anybody ever said otherwise, you would have an argument that it doesn't work that way. The 70% test only comes into play when you are the subcontractor.
There's another exception for companies that are owned by tribes, Alaska Native corporations, or Native Hawaiian organizations where they will not be found affiliated with another company owned by that same tribe, Alaska Native corporation, or Native Hawaiian organization solely based on the contractual relationship between them. So if they have contracts together where one is the prime and one is the subcontractor, or if they provide financial assistance between each other, that would not be the basis for an affiliation finding. In addition to the 70% revenue test, there are other factors that could lead to SBA finding of economic dependence from one company to another. So typically, SBA is not going to find economic dependence based on just one of these factors, but this is the kind of thing that SBA will look at when determining whether one firm is economically dependent on the other. So this is similar to what we saw with the familial relationship identity of interest. So whether the companies are in the same or similar line of business, whether one company has a minority ownership in the other, whether there are any financing arrangements between them, whether one company has a seat on the board of directors of the other, whether the companies are located in the same location, whether there is a strategic relationship between the parties or an exclusive relationship. If there's a contract, exclusivity arrangement where one company will always be the subcontractor for the other, that can definitely, well, that might lead to at least 70% of the revenue coming from one company, but also would show economic dependence. And then also anything that shows the ability to exert influence on the other company, that could lead to economic dependence. And like the other types of identity of interest, there are ways to rebut the finding of economic dependence. So one way to rebut it is if the companies whose size is at issue is a new business. So SBA has accounted for the situation where a new business doesn't have a lot of contracts, so the majority and maybe more than 70% of their revenue is coming from one other company. So these two examples came from SBA. So in the first example, firm A has been in business for 9 months and it has received 2 contracts ever. Because it has only had 2 contracts ever, more than 70% of its revenue is from company B. If there are no other circumstances that would indicate affiliation, SBA likely will not find affiliation because company A is a new business and it just hasn't had the opportunity to go out and get other contracts from other companies. The second example is when company A has been in business for 5 years and it's received 200 contracts. 195 of those contracts are for company B, and that accounts for more than 70% of company A's revenues. In that circumstance, SBA would very likely find affiliation absent something to rebut the finding of affiliation, because company A has been established long enough to go out and get business from other companies, but it's chosen for whatever reason to just have the vast majority of its contracts come from company B. Other ways to rebut economic dependence is just to not be dependent on one other company by diversifying your revenue sources and then engaging in business development efforts to go out and get new business so you won't be dependent on one company. If your size is protested and this comes up as an issue, you want to point to positive trends away from having all or the majority of your revenue coming from one company. So either during that 3-year period or after. If it's during the current fiscal year, you just want to point to a trend away from relying on that other company. Or if you've stopped working with them completely, if you were working on multiple contracts and those contracts have ended before the relevant period of time, or when you're determining your size, that is something you want to point out to the SBA. But to be most effective, the trend has to indicate that you are below that 70% threshold. So maybe in the beginning of the 3-year period, you were at 100%, but now you're down to 65%. That's a trend going in the right direction and would hopefully be helpful to rebut that presumption. Another way to rebut the presumption of economic dependence is to demonstrate why, despite the contractual relationships between the companies, your company is not solely dependent on the other company, because that's really what it comes down to, is dependence. So if you're not dependent on them, you can hopefully demonstrate that you can act independently. So you need to show how your company would be viable without the other company. Whether the contracts that you have with the alleged affiliate are not significant enough to support your company. So they might account for a large percentage of your revenue, but they're not sustaining your business. Or if you are otherwise acting as an independent business, so you're not located in the same place as the alleged affiliate, you're not sharing any resources, you're not working together in a strategic way, you just happen to have had some contracts with them. That's the kind of thing that you would want to show.
Yeah, I mean, if the revenues, if the numbers are not good, they're over 70% for all of the years in question, and we don't have a particularly helpful trend either, then you're in a difficult spot. I mean, it is still a rebuttable presumption, and so, all hope is not lost, although you're probably going to have a tough case. You're just trying to throw everything against the wall that you can to demonstrate that you're not dependent on the other company, that you're independent. So what can you think of? I have my own accounting system. I have my own personnel. I'm in a totally different office. I have lines of credit and other financing that has nothing to do with this company. So I'm viable even without them. You're trying, maybe you have to think outside the box a little bit. Just present the strongest case that you can, and it's advocacy. And there's a fairness and a reasonableness aspect to it, maybe not overtly, but at least subtly in how you present everything. And does the finding of economic dependence, would that be the reasonable result given all of the circumstances? And we got a question a little while ago about when we were talking about the inter-affiliate revenue exemption and whether or not you have to point this out to the SBA, or is it their job to do it? The answer is that you have to point it out to SBA, and that's really the answer for all of this. When we're talking about responding to a protest where you're trying to rebut a presumption of affiliation, or you want to exclude inter-affiliate transfers or what have you, the onus is on you as the small business to give SBA anything and everything they need to rule in your favor. You can't hold it back and expect the SBA will figure it out or understand. You've got to be very detailed. These are some of the most intense projects that we do in helping clients get through size determinations, because they happen rapid fire. Your responses are due in 3 days or 2 days or sometimes even the same day. And it really is on you to give SBA everything they need to make it really easy for SBA to follow the documents or follow the relationship and what you've done to fracture it. So you need to make sure that you're giving SBA everything, because if SBA rules against you, and then you have the right to appeal to an administrative law judge at SBA's Office of Hearings and Appeals, but that administrative law judge, in most, with some exceptions, is not going to let you introduce new evidence that you should have given to the SBA. The judge is going to make a decision based on the record that was before SBA. So you have to build a good record, and that's why you've really got to give them everything that they need. Don't leave it to chance. You've got to point out to them everything that you think works in your favor. And there was also a question when we're talking about the 70% test, does it apply to SDVOSBs? It applies to any business that needs to be small, and an SDVOSB needs to be small. So if an SDVOSB firm is in the role of a subcontractor and is receiving greater than 70% of its revenue from one prime contractor, then that SDVOSB could have an economic dependence and would work the same for a woman-owned small business or a hub-zone firm. It's any company that needs to be a small business, this is a potential issue.
So here we have a couple examples of real-world examples of how a protested company has successfully rebutted the presumption of affiliation based on economic dependence. So in the first one, during the relevant 3-year period, over 70% of the company's revenues came from the alleged affiliate, but the revenue from the alleged affiliate had dropped to 18% of their total revenue by the time of the size determination. So this can happen where the 3-year period we're looking at are the 3 most recent completed fiscal years of the company. So if a size protest is filed later in the fiscal year, the revenue from that year is not considered in the 3-year period. So if the revenue that year had dropped to a low percentage, like in this case 18% from the alleged affiliate, that really shows that the company is going away from their prior dependence on the alleged affiliate, and they're no longer economically dependent. Additionally, in the second example, over 85% of the firm's revenue came from the alleged affiliate during the relevant 3-year period, so that's over the 70% threshold. But the company was able to demonstrate business development opportunities that led to new sources of revenue, and the revenue from the alleged affiliate were not sufficient to sustain the firm's business opportunities. So 2 things helped rebut the presumption there, that the company was actually going out and getting new business successfully, and that even though it was over 85% of their total revenue from this alleged affiliate, it wasn't enough to make them a successful business, or it wasn't enough to sustain their business, so they couldn't be economically dependent on that alleged affiliate. And now we have 2 examples where a protested company was not able to rebut the presumption of affiliation based on economic dependence. So in the first example, the company's revenues from their alleged affiliate decreased from 100% to 70% over the 3-year period, but didn't go below that 70% threshold. And the business could not establish that it would be a viable business without the revenues from the affiliate. In the second example, the revenues from an affiliate were approximately 70% over 5 years, and the company had a strategic alliance with the affiliate, shared locations with the affiliate, and the affiliate had a 45% ownership in the small business. So this is just multiple factors on top of the 70%, more than 70% revenue, that just really showed that the company was, the small business was economically dependent on this other company.
All right. Well, thank you, Julia. That's a good run through on economic dependence. I mean, that's pretty common issue that we're seeing come up in protests. That's actually one of the questions, and we'll go over time here for a few minutes for those that want to stay on to answer questions. Appreciate you staying through 3 o'clock and beyond if you can. But we got a lot of questions, and one of which was, how often does this come up? And I think Julia mentioned, but just to reiterate, it does, we're seeing it more and more. I think ostensible subcontractor affiliation, this is not scientific, but just anecdotally, I still think that's probably the most common size protest ground, but I would put identity of interest right there behind it. It's not too difficult, as Julia said, to do some internet sleuthing to figure out that somebody's wife also has a company, or You find common family names on a corporate filing and you just make the allegation. And the thing is, the bar to file a protest is pretty low. The protester just needs to have some relatively specific allegation and maybe some information they pulled online, and that's enough to get the SBA to open an investigation. And once SBA opens an investigation, you're going under the microscope, and like I said, you've got to give them everything they need to rule in your favor. So let's see here. Somebody asked whether a large loan from a large business to a small business could create an affiliation. And I think I'll give you the typical lawyer answer which is it depends. I mean, the loan in and of itself from a large business to a small business does not automatically create an affiliation. And Julie and I have a recent case on that issue. And what the case law really comes down to, what are the features of that loan? Does the loan itself contain provisions that gives the large business the ability to control the small business? That they can come in and they've got a board seat and managerial rights while the loan is outstanding. Or do they have some non-customary rights in calling the note whenever they want, or taking ownership stake in the company? If it's not a typical looking loan, it's not what SBA would consider to be an arm's length or commercially reasonable loan arrangement, then it could present an issue. And certainly if the small business is dependent on that loan, if that loan is critical financing for the company to operate, that's where there are a number of cases where an affiliation has arisen based on a loan, when the loan is providing funding for the business to operate, and without that loan the business couldn't operate. And that goes to what Julia's point about economic dependence is about the viability of the business. Would the small business be viable without that financial support or revenue that they're receiving from the affiliate? And if the answer is no, they wouldn't be viable, then you've got a real risk of economic dependence. All right, I think we're probably going to wrap it up there, but thank you everybody for joining us. There were a number of questions that we didn't get to, and like I said, some of them were not related to identity of interest, but we will answer them by email as soon as we can. Thank you all again for participating with this webinar. We hope to see you on another webinar soon.